so much for your kind patience to listen to it. Thank you.
Thank you, ma'am. Thank you so much. That puts out the vision of the chair very nicely. Thank you so much. We are now honored to share a special video message from Dr. Gustavo Merino, Director for Social Policies in the Social and Human Science sector at UNESCO. Dr. Merino has held several senior leadership roles globally, including vice minister positions in the government of Mexico. He has also served as CEO of Mexico's National Development Bank for Agriculture and Rural Development and has held leadership roles at the FAO and major academic institutions. He holds a master's and a PhD in public policy from Harvard University and has made significant contributions in public policy, social development, and governance. Due to prior commitments, he is unable to join us live today, but we are deeply grateful that he has shared a recorded video message for this conference. Maybe now please play the video message.
Distinguished representatives of the Government of India, distinguished experts and specialists, dear students, colleagues, partners, friends, although I'm unable to be join you today, I'm delighted to be here through this recorded message for the opening of the International Conference on Clean and Safe Sport at the newly appointed UNESCO chair at the National Law University, Delhi. I warmly congratulate Dr. Roy Paul on her appointment as chairholder and the National Law University, Delhi for its vision and leadership in establishing this important initiative. 2 decades ago, UNESCO member states created the International Convention Against Doping in Sport to provide governments with a clear legal framework for protecting fairness, ethics, and health in sport. Since then, the landscape of sport has been transformed. Competitions now span every corner of the globe. Public investment has risen sharply. Sponsorship, broadcasting, and event hosting carry not only economic weight, but worldwide diplomatic and cultural significance. Simultaneously, sport is becoming increasingly recognized as a force for health, education, gender equality, and peace building, with UNESCO and other key stakeholders building the evidence base to show that just how far-reaching and transformative the potential of sport can be. But with increased recognition comes increased responsibility. Societies and governments now expect more from sport, while the pressures and risks to its integrity grow in parallel. If we want the sport to remain a force for positive change, it must be governed by rules that are not just written, but respected. Legal clarity is the foundation that allows all other safeguards to stand firm, from education to testing to community engagement. This is why the timing of today's conference could not be more important. The Anti-Doping Convention is in the midst of a comprehensive reform process, one which will strengthen its ability to respond to the new challenges and remain effective in the decades ahead. This will be achieved by clarifying the role of governments in the global anti-doping system, improving how compliance with the convention is assessed, securing sustainable funding, and introducing mechanisms to peacefully resolve disputes between state parties. The UNESCO National Law University Delhi Chair will enrich these efforts by exploring the legal underpinnings of effective governance of global sports integrity. In doing so, it will complement the existing UNESCO chair at Université Paris-Nanterre, which examines the social science of anti-doping policies. Together, these chairs will provide a more complete picture of how sports integrity can be strengthened, from understanding community impact to defining legal responsibilities. India's leadership in this field is already well established. I seize the opportunity to congratulate you for the national sports policy adopted last year. As Vice Chairperson of the Convention's Bureau, India plays an active role in guiding the strategic direction of global sports integrity efforts. In addition to consistently contributing to the Fund for the Elimination of Doping in Sport, India has previously chaired the Fund's Approval Committee, has hosted related key intergovernmental meetings, and has provided targeted support to the Convention's reform process, and last year to the celebration of its 20th anniversary. The work of these chairs adds a new dimension to that leadership, linking national expertise to the Convention's global mission. The UNESCO chair will examine how laws can keep pace with scientific advances, uphold ethical standards, and ensure findings are shared for the benefit of all. It will explore means of bridging academic research with the practical needs of policymakers, sport administrators, and legal practitioners. The chair will guide responses to frontier issues in sports law, from new forms of performance enhancement and regulated competitions to the integration of traditional knowledge in safe and compliant practice. The chair will also be key in addressing gender-based violence in sport, recognizing it as a challenge that requires legal safeguards as much as cultural change. Indeed, we must remember that sport is more than an arena of competition. It's a cultural expression, a social activity, and a shared human experience. It both shapes and is shaped by health systems, education systems, community structures, and ethical traditions. This interconnectedness makes legal clarity a precondition for ensuring that the sports benefits are fairly distributed, its risks responsibly managed, and its values consistently upheld. This international conference sends a signal well beyond this campus, especially through its accompanying concrete complementary outputs. On behalf of UNESCO, I recommend the Government of India, the relevant ministries, the National Anti-Doping Agency, and the National Law University Delhi for these valuable new assets and for the commitment and vision that has made this possible. We look forward to working hand in hand with NLU and the Chair for Legal Dimensions of Clean Sports to generate the knowledge and legal insight needed to support state parties implementing the Convention more effectively. I wish all of you success in this important conference. Thank you very much for your attention.
Thank you, Mr. Marino and UNESCO for their continued support and collaboration throughout. We now move to a very important segment, the launch of some of our key initiatives under the chair. And we are honored to have with us Mr. Anant Kumar, Director General and Chief Executive Officer of National Anti-Doping Agency. Mr. Anant Kumar is a career civil servant of the Indian Railway Service of Mechanical Engineers, with an extensive experience of 20 years in various domains of public policy and administration, including sports administration roles in the Government of India. His career has been marked by unwavering dedication to public service and a commitment to fostering transparency, integrity, and good governance. Mr. Kumar has recently taken on the role of Director General and Chief Executive Officer at the National Anti-Doping Agency in India, where he's committed to promoting clean sport practices. As the newly appointed DG and CEO of the NADA, Mr. Kumar envisions a future where athletes can compete in a fair and clean sporting environment. He's resolute in his commitment to eliminate doping in sports and safeguarding the integrity of sports. I now request Dr. Ruhi ma'am to kindly speak a few words about the awareness handbook that we are about to launch, and thereafter Mr. Anant Kumar to formally launch.
Thank you, Diksha. So the UNESCO team at National Law University has created a awareness leaflet regarding anti-doping. This booklet is designed in a very simple language so that it can cater to different category of people who will want to know what are their rights, what are the responsibility in respect of doping related matters. And for this, I like to acknowledge the work which Ms. Udiksha Rana has done in creating this handbook on anti-doping rules regarding rights and responsibility of the athletes and different sports personnels. So now I would like to request DG NADA, Shri Anant Kumarji, to formally digitally launch the leaflet for us.
I digitally launched the handbook on clean sports. Thank you.
Thank you so much, sir, for digitally launching the handbook. Now I would request you to deliver the address to the participants.
Thank you, Dr. Ruhi. Good afternoon, all the dignitaries. It gives me a great pleasure to launch the awareness handbook on clean sports at this international conference on clean and safe sports, organized by UNESCO Chair for Legal Dimension of Clean Sports at National Law University, Delhi. This handbook is designed to empower athletes with clear, practical guidance on anti doping regulations. By making it available digitally, we ensure wider accessibility and promote informed decision making process across the sporting community. This initiative reflects a shared commitment of academia, regulators, and policymakers towards strengthening the culture of clean and safe sports in India. The legal dimensions of clean sport is vital. Anti-doping processes must uphold fairness, proportionality, and due process. Platforms like this conference encourage meaningful dialogue between policymakers, scholars, and regulators. Clean sport is not merely a regulatory obligation, it is the foundation of fairness, credibility, and public trust in sports. Every achievement on the field must represent discipline, hard work, and integrity. NADA remains firmly committed to upholding the principles of the UNESCO International Convention Against Doping in Sport and the Global Anti Doping Framework. Over the years, our focus has expanded from enforcement to prevention, recognizing that education and awareness are the strongest safeguards against doping. NADA is strengthening athlete education initiatives, enhancing intelligence based testing mechanisms, building capacity among coaches and support personnel, and fostering collaboration with academic and legal institutions. As the sport grows more competitive and globally interconnected, our collective responsibility becomes even greater to ensure clean, fair, and safer sports. On behalf of NADA India, I reaffirm our unwavering commitment to fair play, athlete welfare, and integrity of a sport. Thank you. Thank you, Dr. Roy.
Thank you, sir. Thank you so much for joining us, and thank you for the role that you play. We now move towards launching another important academic initiative, our diploma program on clean sports. And it's my privilege to introduce Shri Hari Ranjan Rao, Secretary of Sports at the Ministry of Youth Affairs and Sports. Shri Hari Ranjan Rao is an officer of the Indian Administrative Service of the 1994 batch with extensive leadership experience. He currently serves as the Secretary in the Department of Sports and also holds additional charge as Director General Sports Authority of India. Sri Rao studied Bachelor of Engineering with Electronics and did his post-graduation in Public Policy and Management from IIM Bangalore. With a career spanning key leadership roles across both the state and central government, he is recognized for his dynamic approach and technological acumen. I request Ruhi ma'am to share a few words about the course and thereafter have the program launch.
Thank you, Diksha. So, the UNESCO Chair for Legal Dimensions of Clean Sports at National University is offering an online diploma program on legal dimensions of clean sports, understanding anti-doping regulations. This is an advanced academic and professional certification course offered by the UNESCO Chair in collaboration with NADA, India, and supported by UNESCO Secretariat at International Convention Against Doping in Sports, Paris Nanterre University, South Asian Regional Anti-Doping Organization, Regional Anti-Doping Organization of Central Asia, and West Asia Regional Anti-Doping Organization, along with other international anti-doping and academic partners. This is a program which is designed not just for students, but also for professionals, sports lawyers, athletes, sports personals. And this will be there will be live online lectures in the weekend. And this program extends for 1 year. And we are very happy to be offering such kind of a program from a national law university, obviously supported by NADA. So I would like to request Secretary Sir to digitally launch the diploma program.
Thank you very much. Am I audible? Thank you. I am honored and matter of great pride to launch the diploma program. If that means they're going to be playing of a video, please welcome.
Thank you so much, sir. I would request you to deliver the address to the dignitaries as well as the participants.
Thank you very much. First of all, respected Honorable Justice Anish Dayalji, my colleague in the ministry and DG of NADA, Anantji, Dr. Ruhi Paul, and his very efficient team, and all the esteemed guests who are present today in this very valuable and important workshop subject. It gives me great pleasure to also be part of this exercise, because now I think India is going through an inflection point in the sports journey. And it is very critical for all of us to be part of this journey and also be able to take care of our athletes and their interests. As the sporting ecosystem normally uses the jargon athlete-centric, coach-led sporting ecosystem. And when we talk about athlete-centric sports development, one of the most important aspects of the sport development is clean sport as well as safe sports. So I'm also happy that Dr. Ruhi Paul explained the confluence of safe as well as clean sports and how this workshop is going to talk about it. Let me take a few minutes to also ponder upon the epoch-making journey that Indian sport is going through in the current time. If you're all recalling, last year, Government of India passed a very path-breaking law called National Sports Governance Act 2025. For the first time, India now has a law for the sports governance. Obviously, this Sports Governance Act actually lays down a roadmap for a very transparent and efficient governance of the national sporting federations. And we all know that federations have a very critical role to play in creating an environment for safe and clean sport for our athletes. And we do not have a very checkered, very good history of federations playing very proactive role on these matters, and therefore it becomes very important to have a law. The law also has two important regulatory components to be able to deliver its objective. The Act talks about setting up a national sports board, which will be kind of a regulator which will look after all these federations' compliances to the law and to their own bylaws. And there is going to be a national sports tribunal, which will be a specialized tribunal looking after the matters related to sports. This is again a very, very important milestone in the history and development of sporting regulations in India. I also feel very happy about the fact that Parliament also passed last year a bill called National Anti-Doping Act. Well, it was passed in 2022, but it had not been put into use. Now, with certain amendments, National Anti-Doping Act 2025 amended is going to be also put in place, which is completely aligned with the World Anti-Doping Code and the best practices in the world. Now, it is important to have laws and also to have good practitioners, but there are also challenges in our ecosystem, because we need to have a large number of people who understand these laws and who are able to take it forward and educate our athletes and their coaches to be able to make best use of these laws. And therefore, such chair in National Law University have a very, very crucial and important role to play. And therefore, it gives me great pleasure to be part of this exercise today. I wanted to make a couple of more observations here. India is also honored at this point of time to be the vice chair of UNESCO COP10 Bureau. And it puts onerous responsibility on India and Indian team to be able to take forward the larger agenda in the entire region of Asia, Southeast Asia region, where we need to talk to all these countries, and we have to ensure that a consensus is built up on taking forward the larger objective of UNESCO's COP10 Bureau's objectives. I have been traveling to UNESCO headquarters, and we had also met Professor Gustav, who has delivered his video recorded lecture here today. And when I visited last time to Paris, he was very forthcoming and he was very appreciative of our efforts of setting up the National Law University chair on UNESCO's safe sports. Let me conclude by saying that while we are all here to look after the roadmap for clean and safe sports in the country, it will be useful that our athletes, our students who are pursuing these courses in the diploma, also look into the reasons why many athletes are compelled to adopt practices which can't be considered as clean sport. I think socio-economic challenges in our country, and there are a large number of still regulatory and policy interventions that we need to do. For example, many of our athletes actually end up uh, doping only because they are looking for a certain job that they want to have. And so the motivation is not to win a medal, but to just ensure that they qualify for some competition so that they get a job. Now, this is a challenge which has got nothing to do with the sport per se, or nothing to do with the medal winning prospect for that athlete, but it's a larger social challenge which also needs to be addressed. I will be very happy if all the participants in this workshop, and especially the NLU team, is able to help us in identifying what more additions or changes that we need to do in our existing laws, rules, and bylaws and regulations to make the entire anti-doping system more effective. As far as safe sports is concerned, it's again a very, very important area for us to be able to ensure that our athletes get a fair deal. National Sports Board has a mandate under the National Sport Governance Act 2025 to come up with a safe sports policy, which will be then followed by all the sport bodies and regulators of the federations, and of course all the stakeholders. So again, on those matters also, we look forward to valuable contributions and suggestions from the NLU. And I wish this workshop a great success, and we look forward to getting nuggets of wisdom and suggestions for better implementation of clean and safe food policies in future. Government of India will be always very happy to support and take advantage of the expertise available in our country. And what better than to have NLU standing behind us, giving us the expert opinion. And I'm really grateful to Justice Anish Dayalji for his gracious presence, because that gives the gravitas to this kind of a workshop, which it deserves. With those words, I once again thank you everyone. Good day.
Thank you, sir. Thank you so much for your motivating words. We now move to the keynote segment of the inaugural session, and we're deeply honored to have with us Honorable Mr. Justice Anish Dayal, Judge, High Court of Delhi. Justice Anish Dayal was elevated to the bench of the Delhi High Court in 2022, after having spent 27 years as an advocate and then a senior advocate. He was educated at St. Stephen's College, and where he did his graduation in physics honors, and then completed his degree in law from the University of Cambridge in England. As part of his legal practice, he specialized in media, entertainment, and sports law. He advised a host of entities like broadcasters, sportspersons, sports management companies, media agencies, and federations. As a lawyer, Sir was involved in landmark sports litigation, as well as structuring various leagues. Now, as a judge of the High Court, he hopes that the sports ecosystem continues to evolve and we become a stronger sporting nation. And with that, sir, over to you.
Thank you very much. Can we do a quick audio check? Dr. Paul, can you hear us?
Yes, sir.
Minister Saab?
We can hear.
Okay. All right. And also a disclaimer, I told Dr. Paul I have a really bad throat for the last few days, so don't mind if I cough through this address. So first of all, a big thank you to Dr. Paul for having stitched this together, and I'm so glad to be part of this. As a little bit of my profile was read out, I have been as a lawyer quite intensely involved with sports law and in all its aspects, and was very fortunate to be part of that journey. I must also thank the Honorable Minister. I think your words are very encouraging, sir, and your optimism with this new inflection point. And we are looking forward to the evolution of the new law, and your openness to welcome suggestions. I'm sure as the panelists would give you. So we have some points which I wish to make from the history of my interaction. And I hope they'll be useful. And of course, where I sit, I can only come to these panels and share my views. The rest will be shared through judgments. So, so, but it's a very great start. UNESCO's anchoring in India on this chair, I think, is a fantastic start. For years and years, when we advised on anti-doping law and represented athletes, one of the biggest core of my advocacy was that we should have a full 360 degrees ecosystem, and where academics also comes into the picture, support also comes into the picture. So this is really good that we are starting on this note. So sport is not sport if it is not clean sport. The whole essence of sport is based upon unsullied and ethical competition, a testament to the fortitude of a human being on all fronts. This conference promises to be an excellent platform for discussion on various aspects. While the detailed deliberations will unfold in the technical sessions, it is my endeavor in this keynote to provide context to why and where we are today, and to offer glimpses alongside of my experiences as a legal professional in my earlier avatar in the sports ecosystem. For many years, as mentioned, I have worked with sports persons, sports companies, and governance authorities, and I speak from that vantage point. Sports law was virtually unknown in India in the 90s when I entered the profession. The liberalization of early 90s gave a significant boost to acquisition of live media sports rights, which required enormous amounts of money from acquirers. The interest lay in accessing the huge Indian market and generating sponsorship revenues. These aspects dovetailed into a flurry of activity in the mid-90s between rights acquirers, broadcasters, sponsors, marketers, and sports management agencies. As more money entered the sports ecosystem, it began to firm up structurally, and legal issues followed. Wherever there's money, the legal issues follow. This marked the emergence of sports-related law, which amplified further with the launch of the IPL in 2008, the big daddy of cricketing leagues. I'm just giving a small, very short synopsis of the evolution for people in the audience to understand why are we here today. With the rise of IPL, value of rights and of sports persons suddenly came to the fore, and so did the potential of generating more money through sporting prowess. There was an immediate linkage which was established in terms of sporting. This is about professional sports, but so does it relate in some way to amateur sports. Other sports tried to follow the IPL template. Some succeeded, some did not. But one thing became clear. Sports persons were no longer just playing in the arena, not only chasing national and regional glory, but professional recognition, and therefore bigger pay packets. As the Honorable Minister mentioned, and a very critical point that was made was the need for jobs. And I'll come to that because the socio-economic demography is a big issue in understanding the Indian sports ecosystem. So the urge to do better became paramount. For many sports persons, better meant improved training, better facilities, and greater exposure. For others, it meant unsavory routes like doping, age frauds, and match fixing. The idea of clean sport, therefore, emerged as an urgent and rising concern. That's how concepts of India tackled this in several ways. Most importantly, by instituting the National Anti-Doping Organization, called NADA, along with the adjudicatory authorities at both the first instance and the appellate level. Testing began. Results showed there was abuse of substances for the purposes of getting better results. While athletes who deliberately cheated were caught, others who were poorly managed or inadequately coached were also caught in the net. There was a huge ethical chasm between advertent doping and inadvertent doping. Many athletes caught in this were often unrepresented and needed legal representation. Having some experience in the field, I pitched in with my legal services, mostly pro bono, to ensure that athletes received fair representation before adjudicating authorities. Through this process, I came into close contact with athletes and came to understand their dilemmas, their anxieties, their coaching environments, and the inadequacy of the awareness. I used to be an often frequent visitor to the appellate and the authorities at NADA before the current DG was there, much before. This is back when I was a lawyer. So, but as a part of appearing for athletes, I used to interact with them, talk to them about their problems. And a lot of my sense about how it's on the ground is through those interactions. What I wish to emphasize is this: while clean sports is the stated objective, are we just targeting the athlete and ignoring others who push them to take that substance or that route? And this is a critical point I wish to make. While some athletes get caught in the net, no doubt, because there's strict liability of presence of substance in your system, people responsible for it are often active out there, which includes coaches, which includes support personnel. If clean sports is the agenda, it requires a much larger vision than just focusing on testing and athlete bans. If we are just focusing on that, we are just not doing enough. It's just the tip of the iceberg. The minister's vision that we need to clean up, it has to be a deeper dive. And what the executive ends up doing, or the policymakers end up doing, it is the right time at this inflection point to look into those issues. I've had athletes clearly tell me that I was forced by my coach to take this. Wrong or right, the point is that the coach was never in the picture, always absent. And the coach is also doing it for their own glory, for their own financial take in the process. Or there were nutrition specialists or doctors. Wrestlers would come to us from Punjab saying that, well, I had a problem, I had fever, went to the local doctor, he gave me this, and it contains a banned substance. Now, the doctor, we don't expect the doctor in some semi-rural area of Punjab to know what is the pharmacological list or the prohibited substances list. So we have to see the whole stream in our cultural context. We can't import a Western model. We must import the Western model because we have to align with the global system. But we must develop things locally in India in order to find out what the problems are and where the problems lie. The approach, therefore, and that's my point, cannot be retributive. It cannot be just handing down bans. It destroys an athlete's life if you hand down a 4-year ban, sometimes incorrectly. As in the review which was done by WADA of NDTL, they realized that there were so many bans which were handed down which are not correct, the adverse analytical findings. So there is something to be said in handing down bans. But the approach in my submission has to be preventive. But preventive requires effort. Preventive requires effort. It requires a deeper analysis as to what are the reasons for cheating. And I'm hoping, after I heard Honorable Minister's profile, being a policy person, and I hope, sir, that you use what we have learned in our colleges in doing statistical analysis and deeper analysis. We must use that in the fore now. It has to rope in all stakeholders in the ecosystem: coaches, administrators, nutritionists, support personnel. It starts with awareness at a deeper level among us athletes, involves reaching out to athletes at all levels, in their language, in their vernacular. for them to understand what clean sports involves. I was looking at the launch of the awareness handbook, Dr. Paul, and I had worked on some other version previously with the foundation. One of the big issues we had is, and in my interaction with athletes, was they don't understand English. They are coming from mostly semi-rural backgrounds. No urban child is on the top of sports today. If you do a statistical analysis of the demography that they come from, then are we then dealing with their literacy, with their vernacular? How do we tell somebody coming from a tribal village in English about their law and rights? That's a very critical issue. Somebody needs to look at this. So whatever you are publishing today with the technologies available, Honorable Minister is a technologist, with technologies available, you can easily do translations in vernacular. If you need to reach out to that sports person, raise that awareness, please use the vernacular. We must use our local languages. It also involves making athletes aware that if they fall on the wayside for reasons not related to any cheating, they have the possibility of having right representation. Legal sensitization is therefore the necessary for levels of coaches and nutrition supporters. This is where the legal fraternity also comes into the picture. We tried to organize cadres of young lawyers to say that whoever interested in the domain, to make sure that athletes could be counseled, athletes could be guided, at least they could be properly represented. I hope those initiatives have come to fruition somewhere. I've obviously lost track for some time. The process must be streamlined, but this has been a tough journey. If India is not doing well on the doping chart, the reasons have to be crunched out of the data which is available. WADA's report has a detail. It's a bit of a blemish on India, I can understand, but there's a lot of detail in the statistics to be done. For example, we have lesser tests and therefore our percentage rate is higher. So somebody has to sit down and figure out why those numbers are there and what is the statistical spectrum in which those numbers are there. We may do better next time if we can only do that data crunch. Merely pointing a finger is not going to work. A scientific analysis needs to be undertaken. The new sports policy or the National Sports Governance Act, in my mind, do not contain elements of a larger initiative. I have gone through it, both the policy and the act. The act talks of safe sports, and it's a specific concept of safe sports. But somehow, except for the NADA part, we don't really see something on clean sports. And I would ask the Honorable Minister that at this inflection point, when things are still modulating, to please look into it so that it gets firmly anchored. Clean sports cannot be anchored only with NADA. NADA is one body which talks about anti-doping and of course has its own sets of issues. But clean sports cannot be just a byword. It has to be anchored in some policy under the act, outside from the act, somewhere. The reason I say this, because traditional anti-doping, traditional doping issues are now traditional. What we are seeing emerging in the world now is various forms: gene doping, microdosing, designer drugs, blood manipulation, hormone manipulation, cognitive enhancers. Who's going to catch them? So with India, which is fantastic with its innovation, which is fantastic with its pharmacological industry, we are doing very well in those industries. We are pretty much cutting edge. There's no reason why that knowledge and language is not imported and used for the sports ecosystem. Otherwise, we will have people with resources and trainers with resources bypassing the traditional doping mechanisms. And we will be twiddling our thumbs. So one does wonder how we will be in a position to tackle these new age performance enhancers, which gives an unfair advantage. There are serious challenges. For India to become a frontline sporting nation, this assumes criticality. So I'm glad overall. I've just highlighted some points. I didn't want to stretch this too far. I have a long list of points in my head, but what I thought is the thematic issues which I can share with you all. I have done that, and I hope, and I'm very glad that NLU is taking this initiative. Dr. Paul at the front and your resource people, and I hope that these results and the deliberations are useful. It may help to give it to the minister and to the DG NADA and the other people in the hot seat, so they should be able to take it to some kind of logical conclusion. So thank you so much. Thank you.
Thank you, sir, for putting out the problems and challenges that are mostly not very apparent and obvious when we talk about clean sports. May I request Ruhi ma'am to give a vote of thanks?
Yes, thank you, Odiksha. So this brings us to the end of the inaugural program for the first International Conference of Clean on Safe Sports. I'm very happy to propose a vote of thanks to Honorable Mr. Justice Anish Dayal, Judge High Court of Delhi. So thank you so much for raising those uncomfortable questions. And I would like to inform you that we have plans to translate this handbook into vernacular language. We thought we'll introduce within the English and then we will translate it. And also we are going to be undertaking research in neurodoping and privacy issues of the athletes in near future. We have written research grant proposal for these two topics with the help of NADA and Sports Authority of India. I'm also very thankful to Sir for expressing his desire to us on his own in spite of all his busy schedule to guide the UNESCO chair at NLU Delhi. Thank you so much, sir, for your support and guidance and your offer to work with the chair in near future and your ideas that we have discussed in the last meeting. Thank you so much, sir, for all your support and guidance. I'm very thankful to Shri Hari Ranjan Rao, Secretary Sports, Ministry of Youth Affairs and Sports, Government of India. So thank you so much for your support for various activities of the chair, as well as I also like to share this moment to thank you for nominating staff members from Sports Authority of India as well as from NADA for our online diploma program. Thank you so much, sir, for joining us today for the inaugural session. And thank you for your valuable suggestions and words of motivation. I'm also very thankful to Shri Anant Kumar, Director General NADA India. So thank you so much for all your support for our various activities and for launching the diploma program in collaboration with us. This would not have been possible without the active support of NADA. Also thankful for nominating certain officials for joining the diploma program. I would also like to take this opportunity to thank Dr. Sonika from NADA, who has been in constant touch with us, and she's the person whom we are disturbing day in and day out for all various activities, also for last minute help from NADA. Thank you so much, Sonika ji. I also like to thank UNESCO anti-doping team for all the support that they have given to us for various chair-related activities and supporting us in this inaugural session by giving us a video message of Mr. Gustave Merino. I also would like to thank our Vice Chancellor, Professor G.S. Bajpai, for all the support that he gives to the initiatives of the chair, as well as for all other activities of the faculty member and the students at National University Delhi. I would like to take the opportunity to thank the team member, core team members, Ms. Odiksha and Mr. Gaurav, Mr. Anil Menon, for all their support, working day and night for the successful conception of the idea of this international conference and all the nitty-gritties of these two-day event that is going to be unfolding in some time. Also, I would like to take this opportunity to thank the IT department comprising of Mr. Gurjinder, Mr. Rohit, and Mr. Manoj for all their technical support for this virtual program, which would not have been possible without the support of the IT personnel of the university. I would also like to thank all the faculty members, the staff members, the participants who have joined us in this inaugural program. Thank you one and all. Namaskar. So we can take a short break of 1 or 2 minutes, and I'll, in the meantime, let our panelists for the expert colloquium join us, and then we can start the expert colloquium.
Dr. Paul, are we continuing on this link?
Yes, sir. We are continuing
All
on
right.
this link only. Udiksha, can you see the panelist already joined us, or?
Ma'am, I can see Lovely ma'am joined us. Vidushpat sir has also joined us.
Mhm.
And
Graham, I'm talking to Mr. Graham. He's joined? Okay. So Mr. Graham Arthur also has joined. Who else is there?
Mr. Siddharth has also joined.
So is there anybody left?
I think, ma'am, we're good to go. Good to start.
Okay. Sir, can we start? Dayal sir, can we start?
Yes.
Okay. Over to you, Diksha.
Thank you, ma'am. So we now move to the next very important segment of today's program, which is the expert colloquium on clean sports, which is centered around the theme Clean Sport in Transition, Law, Governance, Policy, and Athlete Justice. The session brings together leading experts in sports law, dispute resolution, anti-doping governance, and policy to help us understand how clean sports systems evolve and run. I would start with the introduction, and we're deeply honored to have with us Honorable Mr. Justice Anish Dayal. I would take a minute to introduce Sir again for the expert panelists. Justice Dayal was elevated to the Delhi High Court in 2022 after a distinguished legal career spanning nearly 3 decades as an advocate and senior advocate. A graduate of St. Stephen's College and University of Cambridge, he has specialized extensively in media, entertainment, and sports law. During his practice, he's advised broadcasters, sports federations, and represented Olympic-level athletes before anti-doping authorities and CAS. He's also been deeply involved in advancing athlete rights and awareness within the sports ecosystem and has contributed to the sports law scholarship and teaching. We're truly privileged to have your Lordship guiding this conversation today. I'm also delighted to have with us Mr. Graham Arthur. He's an independent sports lawyer in United Kingdom. Mr. Arthur has extensive experience in sports regulation, anti-doping governance, and sports policy. He regularly advises organizations and represents clients in anti-doping and governance matter at both national levels and before the Court of Arbitration for Sport. He previously served as Director of Legal at UK Anti-Doping, where he led prosecutions and investigations of anti-doping rule violations, and has also closely worked with global institutions, including UNESCO and Council of Europe on anti-doping policy development. We're extremely grateful for your presence with us today, sir. I'm also very honored to have with us Professor Dr. Lovely Dasgupta, Director, Center for Sports Law and Policy at the West Bengal National University of Juridical Sciences. Professor Dasgupta has been in academia for over 16 years and is among the pioneering scholars who introduced structured teaching of sports law in India. Ma'am has authored multiple books and extensively researched sports governance and anti-doping regulations. She currently leads the Center for Sports Law and Policy at the National University of Juridical Sciences, Kolkata, and is the only Indian member of International Network of Doping Research based at Aarhus University, Denmark. And ma'am's work has also contributed significantly to legal education scholarship in India. Thank you, ma'am, for joining us. And it will be really wonderful to have your academic insights. We're also pleased to have with us Mr. Siddharth Nayak, who's the founder and managing partner of Atharva Legal. Mr. Nayak has been closely involved in several important sports governance and regulatory matters in India, and has contributed to evolving policy and frameworks within the Indian sports, and has actively worked on issues related to athlete rights and the regulatory compliance. Sir has also previously engaged with us during our policy discussions and roundtables on sports governance and sports policy, and continues to be a strong voice in our conversations. We're happy to have again with us today. Thank you, sir. And lastly, we are honored to have with us Mr. Vidushpat Singhania. He's the managing partner of Creeda Legal. Mr. Singhania is among India's leading sports law practitioners and has been widely recognized internationally, including being named among Forbes' top 100 lawyers and Business World 40 under 40. Sir has played a key role in drafting major sports policy and legislative frameworks, including the National Sports Development Bill, National Sports Fraud Bill, and the National Anti-Doping Act 2022, and has represented major sports organizations and athletes before courts, arbitral tribunals, and anti-doping authorities. He's also co-author of leading reference work, Law and Sports in India. We are privileged to have all the panelists with us today. And with that, it is my honor to hand over the session to Professor Dr. Ruhi Paul, who would be moderating the session and taking the discussion forward. Thank you.
Thank you, Riksha, and thank you to all the experts for joining the expert colloquium today on a request. In India, the resolution of sports disputes and enforcement of clean sports have evolved from a fragmented system of internal federation mechanisms to statutory framework under the National Anti-Doping Act. This legal structure aims to balance the strict liability of anti-doping rules with the athlete's constitutional right to fair trial. We have various key institutions like NADA, we have Sports Federation, we have National Board for Anti-Doping in Sports who are performing their various activities. While within the framework provides for due process, several barriers impacts an athlete's access to fair justice, like strict liability for any anti-doping violation versus the intention and the impact this kind of strict liability has on the careers of the sports personnels. There are economic and legal barriers in respect of accessing the systems for redressal of disputes. There are issues of procedural fairness. Critics have highlighted issues such as inconsistent decisions by the ADTPs and the lack of specified grounds for removing panel members, which could impact the independence of the adjudication process. Indian courts have increasingly viewed sports disputes through the lens of Article 14 and Article 21 of the Constitution of India, emphasizing that state-recognized sports bodies must act in non-arbitrary and transparent manners. Recent legislative updates such as the National Anti-Doping Act seek to further strengthen NADA's independence and mandate that all labs maintain BARDA accreditation to ensure technical reliability in sport reports. So I think with this background, I would like to invite Justice Anish Dayal to give his expert insights on the topic.
Hi, good afternoon, everybody. Dr. Paul has forced me to do 2 sessions back to back with a bad throat, but I'll manage. So, well, we can see Graham there as well, Mr. Arthur. Yes, good. It must be early in the morning for you.
No, it's fine. It's actually 9:45.
All right. Okay. Ms. Das Gupta.
Yeah, that's fine.
Good afternoon. We've crossed paths earlier. Good to see you.
Yes, sir.
You're the resident.
Good to see
You're the
you.
resident expert. Unfortunately, we are online, but it obviously helps access. But it's always great to sit and have some body language in a panel, but we'll do so. Okay, so I'm going to touch on these three broad aspects. Governance, dispute resolution through the new process of tribunals, and the third is athletes' access to justice. Some of what I want to say might be generic, but I'm also in my position as a judge, I don't want to make a comment before adjudication on a particular provision of law. So, but I wanted to say that clean sports does not mean only fair play and no cheating. It also means that sports is free of avarice, nepotism, favoritism, bias, and corruption. We often sort of tend to address clean sports only in that limited manner, but clean sports must be a broader issue. What have we done to tackle these ills and evils in our system? Policy, regulation, law, they provide only broader structures, but the crux is to eliminate these on the ground. Administration and governance, therefore, needs to be responsive, empathetic, supportive, and alert. This is where the role of governance comes in hugely. And there's some dichotomy in the way governance works when looking at issues of clean sport. Ethics, therefore, need to percolate into the system. Each stakeholder in a sports ecosystem has to approach issues through the prism of athlete first. Since the fundamental issue, which I often point out or used to point out when I was a lawyer and advocating these issues, was that the crux of a sports ecosystem is the athlete. So you have to see it from the prism of the athlete when you're looking at policy, regulation, and law. Governance is rickety, with the reins in the hands of despotic sports administrators and federation heads. Factional disputes are rife within these federations, as I'm sure they are in other parts of the world. However, whereas there was no judicial review which was existing prior, the Delhi High Court stepped in with momentous and landmark cases and punctured that insulation of autonomy. Autonomy, as you would know, and I'm talking from a legal perspective, the whole sports federation system works in a pyramidal hierarchy: international, national, regional, city level. And each is beholden to the other in the upper rung. Therefore, and they were meant to be autonomous, as is the traditional system, away from government control, away from any other regulatory control, but the only control was within the system. That insulation offered people who were politically inclined, politically means the sports politics inclined, to get their way with the system. That insulation, the High Court and the Delhi High Court in particular, punctured by innovative jurisprudence all through the last 2 decades, and brought in judicial review to cut that mad practice, to ensure fair decision making. So that's the first point in terms of where we are getting to dispute resolution. We must understand that. Today,
email भेजिए, print out चाहिए उसका.
Dr. Paul, I think, yeah, sorry. No, I think you're not on mute. Okay. You must understand that when we are talking about new concepts coming in, like the tribunal, today, the High Court in particular has numerous sports-related disputes: election disputes, factional disputes, age issues, selection disputes. And sometimes when I sit on particular benches, I'm also faced with them. And I'm prone to just smile, and people, I sort of, since I've known the system, it's not changed too much. Rightly, therefore, maybe, that the government brought in the National Sports Governance Act. So let's move to the next level, which now stands notified. Only parts have been implemented. It recognizes the Olympic Charter, the Paralympic Charter, focusing on ethical behavior and alignment with global governance standards. Today, it's an inflection point. It recognizes that national sports governing bodies discharge important public functions and should be open, fair, and transparent. A number of bodies are proposed under the Act, the national sports body being the overarching regulator with oversight powers, along with various subcommittees for athletes, dispute resolution, ethics, and executives. Now, what is this body expected to do? This body is expected to control recognition to the sports organizations, affiliation, de-affiliation, respond to complaints, conduct inquiries, formulate a code of ethics, and frame a safe sports policy, broadly speaking. It also is to prescribe measures to ensure protection of rights and welfare of athletes. Now, having the new legislation having been notified from 1st January 2026, we are still to see how it's going to play out. There is some criticism, I must say, on a few fronts. One is the lack of autonomy of such a national sports body, which somehow is in direct conflict with the Olympic Charter, particularly Rule 27. But having said that, today, having lived with the collection of guidelines which we call the Sports Code, which the court gave its jurisprudential imprimatur to, it's better to have a codified thing in front of us for us to test it and see whether it works. Now the Act has been notified. It is through stages of implementation. Various aspects will evolve. So we have to now look at the new structure and whether we are able to sustain the solutions to problems and a ready solution to problems which arise in the sports ecosystem. We have to understand one thing, is that sports disputes are perishable in nature. An athlete wanting to be selected and unfairly sidelined in a selection process comes to the court in a writ petition seeking a direction from the court. The court has to go into it. The tournament is sometimes 1 week later, 3 days later, and there is a ham-handedness of the federation which is seen in that. Now so it's a perishable dispute. There's no point if the court ends up giving a date of 1 month, 2 months, 3 months. The athlete has lost its opportunity to play in that particular tournament. So that has a massive impact. Because of the perishable nature, it is important to have speedy resolution of disputes. Now, how are we dealing with that issue today? The National Sports Governance Act talks about the National Sports Tribunal. Now, there's a history to this whole evolution of a tribunalized system for sports adjudication. Globally, resolution has veered towards arbitral processes. We have Sporting Resolutions UK, we have various other systems available, and of course, at the highest level, CAS, which is an arbitral body, and it's critical to understand that. Now, what does the tribunal do? There'll be a tribunal headed by a retired judge of the Supreme Court or the Chief Justice of a High Court. However, what is interesting is that the nature of disputes that the tribunal has to take into its fold is not clear from a reading of the Act. It has an exclusionary provision in Section 20, which talks about certain international aspects which the tribunal cannot take into account, but it does not talk about the whole panoply of sports disputes which must come to it, at least in my cursory reading of it. It does say that all disputes before the courts where federations are a party will be transferred to the tribunal, but that is not all. It's ignoring various other sporting disputes which relate to unfair selection, allegations of sexual harassment, infrastructure deficiencies, contractual disputes, discrimination, and others. So right now, I'm not particularly clear. Maybe your deliberations will work that out. The other issue which the dispute resolution process through a tribunal conjures up is that the proceedings are judicial in nature. It's adversarial. There is a adjudicator, and it is not similar to arbitration. The tribunal has civil procedure powers, and appeals against the orders of the tribunal go to the Supreme Court directly. Now that is very interesting. So a judicial order in a sports matter rendered by the tribunal will be appealed before the Supreme Court. All well with that. Otherwise, in an international system, it is supposed to go to CAS, anything if it's an international issue. Now look, the fact that it goes to CAS in a small exceptional category is very interesting. A judicial order will then go into arbitration before CAS. There is some kind of a disharmony there. Maybe Graham is able to throw light on it, but that is always a problem. That is always judicially, the alignment is a problem, because CAS is necessarily an arbitral process. So therefore, how does it align? How does a tribunal align with the process of CAS? We don't know. How will CAS sit in an appeal over a judicial decision of a legislatively organized tribunal in India? I'm not sure. As far as CAS is concerned, and Graham may find these comments slightly pointed, but I wish to share this. I've had experience with CAS as a lawyer. I had appeared for a number of Indian athletes. Mr. Singhania is there, who's done a lot of heavy load bearing on this issue. But what we find is, from the perspective of an Indian athlete, because those are the ones we were representing, that it is prohibitive, not only for costs, but for logistics and inaccessibility. CAS is Eurocentric. And even though it provides a very well recognized, very well-oiled body, and we can say it with responsibility, at least as a lawyer, we found it extremely difficult. And I'll give you two examples, illustrations. We're representing a judoka, gold medalist, who won. There was an adverse finding. We won in two instances. The first instance before the NADA authorities and the appellate adjudicatory authority, which are well constituted, manned by judges. But in the WADA appeal to CAS, which the judoka could not represent well, and I'll tell you why in a minute, she lost. WADA sent a bill. Because WADA won, CAS sent us a regime of costs. We had to plead that she can't pay. And why? Because she had a job. She was a police constable. Had a job as a police constable. Was earning a few hundreds of dollars per month, as is the equivalent rate in India is. How would she pay some few thousand francs for an appeal by WADA against two levels of positive decisions in her favor? I could never understand that. We applied for legal aid, etc., etc. So you are left in a situation where you are unable to be represented. You have no logistical manner to represent. And it's a practical difficulty. I'm sure it can be, if CAS was confronted, it will say, well, you have online systems, etc., etc. But I'll tell you the difficulty. in another Olympic athlete, a shot putter. Again, we won here, and the appeal was taken to CAS. Having the experience of lack of representation, I asked my English barrister friend in London to represent the athlete because I thought that may be easier. And he was able to do it online because there was no physical hearing that time. No, I'm wrong, actually. I think it was physically in Lausanne. But the ban was sustained because we didn't have access to tremendous amounts of scientific analysis which WADA could provide from their own scientists. In a strict liability issue, there's so much of little scope for an athlete trying to plead certain other issues. However, we can't argue against the World Anti-Doping Code, and there's no difficulty. But I'm just pointing out, in a structural basis, I don't see why CAS does not evolve a system where the whole world, athletes from the world, find it easier to access. Maybe it has changed in the last few years when I've been on the bench and I've not been aware of it. But why don't we have regional panels? If you're talking about access to justice, quote unquote, then why are there no regional panels if CAS is ultimately of importance? And it will continue to be because we are in the WADA system. That is one issue that I want to highlight. And it will be nice if in this panel, Graham is able to address that. The third thing is athlete awareness, the third point. We have to see athletes, as I said in the inaugural, in their cultural context. In my interaction with athletes here, we are a large, diverse country with multiple languages, multiple national languages and multiple used languages. Athletes come not from urban centers. And this is very different from a situation in the Europe or the West. They come from semi-rural or rural backgrounds because they have that energy and that fire in their belly to succeed for economic benefit. Now, those athletes do not have the wherewithal, do not have access to their rights because of the bar of language. That I have addressed also in the inaugural session. That has to be seen very seriously, both in documentation that is provided to them and as well as support which is given to them. A handbook, a prohibited list is not going to be understood by an athlete. And if it has to be translated to an athlete to say that, well, these are the substances which are prohibited. If you take a cough syrup from off the shelf, that might have a prohibited substance. We did multiple cases, Mr. Singhania would remember. We did multiple cases on that front, and you were banned. How do we plug that loophole? Somebody taking a cough syrup. So some methods have to be involved in that. The other issue is of athlete counseling when we are talking about athletes' rights, which ought to be the responsibility of federations. When athletes are expected to remain beholden to their federation bosses, perhaps some solution lies in the legal fraternity stepping up. Perhaps some solution lies in support personnel stepping up, providing counseling to an athlete when they feel aggrieved or victimized. I have consistently advocated this. We put together a pro bono legal counseling service with a raft of young lawyers, but I don't know how that has shaped up, and I don't know how that has fared. However, my concern still remains. So I'll end. I've touched on my 3 points, my little bit, and I don't know if I've overshot my time, but I hope not. Thank you.
So much, sir, for raising the issue of athlete awareness, also about the issues with the national adjudication of sports dispute, as well as highlighting the issue of access to CAS. You have already set the tone for our next speaker. Thank you so much for doing that. Thank you for your input, sir. be assured that the chair will obviously be looking into your suggestions, and we will try to work something towards contribute towards these issues that you have raised. Now, the Court of Arbitration for Sports, headquartered in Switzerland, serve as an ultimate international authority for resolving sport-related disputes, including those concerning clean sports. Access to CAS is typically established through arbitration clauses in an athlete's contract, a sports federation constitution, or the World Anti-Doping Code. There are 3 types of access to CAS. First is the Appellate Arbitration Division. Second is Anti-Doping Division. And the third is the Ad Hoc Division, which is the temporary offices which are established during major sporting events like the Olympics to resolve dispute within a 24-hour time frame. There are a number of other key features also, as in respect of accessibility and support to address the financial barriers. The CAS provides a legal aid fund and access to pro bono counsel for athletes who lack sufficient means. With this brief introduction about CAS and the working of CAS, I would like to invite Mr. Arthur Graham to give his intervention on the topic of clean sports, dispute adjudication, access to Court of Arbitration for Sport, that is CAS. Over to you, Mr. Arthur.
Sorry, Professor Paul, I was just unmuting myself. I'm just going to share my screen. Right. There we go. So can I just confirm, Professor Paul, you can see my screen there, the first screen of my presentation?
I can see it. Please
Brilliant. Okay, well, I'll proceed. Thank you. Thank you for that very kind introduction. I agree with what you said there, that the CAS does have quite a broad jurisdiction in relation to the anti-doping world. I'm going to focus actually in this brief intervention just with a few remarks about CAS's role in relation to appeals, because the issues that flow from that, including some of the very interesting issues that Mr. Justice Dyer has referred us to, that flow from appeals, but they also have application across all of CAS's jurisdiction. So in relation to appeals, the World Anti-Doping Code establishes the Court of Arbitration for Sport as being an appellate body for anti-doping disputes through Article 13. And specifically, that jurisdiction can arise in relation to both international athletes and national athletes. Now, in relation to international athletes, which we don't need to drill into the detail of what constitutes an international athlete, but very broadly, it's somebody who participates against fellow teams or competitors from other nations. Appeals involving those athletes, they have to go to CAS. So if there's a doping case nationally involving an international athlete or one from an IF, and there's an appeal, that must go to CAS. And the position with national level athletes is that the International Federation and WADA can appeal national level decisions straight to CAS if they want to. In particular, WADA doesn't have to appeal domestically. So there's quite a broad range of appeal rights available to all of the key bodies in an anti-doping case to ultimately go to the Court of Arbitration for Sport if they wish to. Now, in relation to why have the Court of Arbitration for Sport, well, the World Anti-Doping Code emphasizes that its purpose is to protect athletes' fundamental rights to access clean sport and participate in clean sport. Now, one of the ways that you do that is that you make sure that everybody plays by the same rules. And in relation to the anti-doping framework, you want to be sure that everybody worldwide, all the people that you're competing against, they are all subject to the same anti-doping standards, rules, and processes that you are. Because if it's not fair. And so that harmonization and coordination function of the World Anti-Doping Code is core to its philosophy. And that is why the Court of Arbitration for Sport is there, because to use this slightly sort of pithy slide, it's to ensure consistency. And Professor Paul referred to this in her opening remarks. The need for consistency across the anti-doping world is vital when it comes to a perception of fairness as well as the reality of fairness. Now, in that respect, the Court of Arbitration for Sport maybe has, I'd say, at least three really strong features that make it a very attractive and a very useful and worthwhile body to provide this consistency guarantor when it comes to the application of the anti-doping rules. The first advantage, which will appeal to anybody who is a legal practitioner, is that its case law forms part of a big corpus of authorities that enable practitioners, athletes, stakeholders to understand how the code and national anti-doping rules are and should be interpreted. The code is a very detailed and long document, and like all long, detailed legal instruments, there are areas of interpretation and subjectivity that need to have some rationalization through an ultimate decision-making body, and CAS provides that, and it provides an ongoing resource to practitioners through its jurisprudence database. The decisions, by and large, are not confidential. They are all available from CAS to provide an ongoing guidance to how the code should be operated and interpreted. In that respect, the Court of Arbitration for Sport benefits from a geographically and jurisdictionally diverse community of arbitrators. Mr. Justice Dial referred earlier to one of the problems with CAS being its Eurocentrism. And I tend to agree with his thoughts on that, and I'll come back to that in a few moments. But one area where I think it's reassuring that CAS is not Eurocentric is in the diverse source of its arbitration practitioners. The screenshot I've shown here shows how diverse it is. There are arbitrators here from India, from Europe, from Africa, and Oceania. So there is a diversity of expertise, which is always important when it comes to the credibility and robustness of decisions. And the third feature is that CAS has been somewhat tested in order to make sure that it complies with the law. Now, as sport practitioners, we're all familiar with sport laws. The laws of cricket are laws that we all love and respect as being very important parts of our cultures. But the sport itself, does sport need to comply with the law, is an issue that's sort of interested in exercise practitioners for some time. And in that respect, the European Court of Human Rights has examined some of CAS's features. The person in the slide here is Sylvia Pechstein. She was I think maybe still is, an international speed skater, and in cases involving her and a footballer, Adrian Mutu, the European Court of Human Rights was able to uphold that specific features of CAS's practice were compatible with the right to a fair hearing, which in turn provides a degree of reassurance and comfort to people that when CAS rules on disputes, it's doing in a way that's compatible with international human rights standards. So they're the good things. They're the things why CAS is good. However, there are some challenges to CAS, and I'll deal with a few of those, which actually echo in many ways the remarks that Mr. Justice Dial made before me. So this rather dull slide, I apologise, is nevertheless important because it does illustrate the disparity in access to justice that's built into the CAS process. So if you look here on the left, the national level athlete, can a national level athlete go to CAS to get redress? No, he or she can't. If you're a national level athlete, you can't go to CAS. But you'll see from this sort of diagram that actually the International Federation of WADA, they can. So when it comes to national level athletes, they get 2 appeal rights in effect, and the athlete only gets 1. If you're an international athlete, well, yes, you get to go to CAS, but you've got to go to CAS, and this echoes again some of the challenges that Mr. Justice Dahal mentioned in terms of costs and access to justice. If you're an international level athlete, you might not want to go to CAS. You might be very happy to go to your national appeal body, but the way that the code is set up at the moment doesn't let you do that. And I think an illustration of how that might result in injustice is in relation to the case of an athlete that I've just put on the screen here. This athlete is a shot putter called Mark Dry, and he was involved in an anti-doping case in the United Kingdom that concerned his providing some low-level location information to enable him to be found for testing. The testers tried to find him at that location, and he wasn't there. A fairly routine sort of situation. Subsequent to that, he provided misleading information as to why he hadn't been at his location. That subsequently turned out to be false, and he admitted that he'd lied about why he hadn't made his test. Now, obviously, you shouldn't do that, but lying after a missed test about where you were is not an anti-doping rule violation. It's not tampering. Nevertheless, the National Anti-Doping Organization took a tampering case against him, and he was banned for 4 years. He appealed, and unfortunately, the National Anti-Doping Panel upheld that ban. Now, this is, I mean, widely considered to be just wrong. Those decisions just aren't correct. And the fact is, every panel makes mistakes. No panel never makes mistakes. And in this case, the UK Anti-Doping Panel made a pretty big mistake when it came to the application of the rules in this case. But the problem for him was that was it for him. He couldn't go to CAS and ask for that situation to be fixed. And you'll see here that this is a press statement by an athlete's rights advocacy organisation about this case, where it called on both, in effect, World Athletics and WADA to go to CAS and exercise their right to appeal to fix this. Now, they don't have to do that, and in this case, they declined to do that. But it does illustrate the problem that athletes have if they can't go to CAS to get justice in situations where that justice really should be provided to remedy wrong decisions. Now, just summing up some of the other challenges with CAS, and I'll touch on when I've gone through these on some of the points that mentioned. There are challenges to an athlete in relation to CAS that they are important to mention, and as Mr. Justice Dahal very absolutely correctly said, athletes are at the crux and the centre of the anti-doping framework, and it has to work for them. If it doesn't work for them, then it's not working. And in some respects, the CAS framework doesn't work as well as we'd like it to. So using India, or using a lot of jurisdictions as an example, if an athlete wants to appeal nationally, that's usually cost-free, but at CAS you have to pay. At the national level, if you want to appeal, then generally the process itself is free. There's no filing fee, but the process itself is free. At CAS, you have to pay advance costs for an arbitration unless you receive legal support. The cases that I'm doing at the moment, a typical amount of advance costs would be around 5,000 to 10,000 Swiss francs. They're just the advance costs as well. At the national appeal body, the process will be within the athlete's jurisdiction, so geographically advantageous, and also in the athlete's language, which is often very important. Whereas at CAS, the process is generally in English, French, or a very limited number of alternative languages. And finally, at the national level, if an athlete is unsuccessful in an appeal or is appealed against and the appealing body succeeds, then generally there's no costs award made against that athlete. Absent any bad faith or malice, there's no costs award made against the athlete. But in CAS, quite significant costs awards can be made against an athlete, and Mr. Justice Dahal mentioned an example of a case where that had happened. Now, these can happen where an athlete appeals but is unsuccessful, or another party appeals and is successful against the athlete. And whilst the costs ultimately are in the jurisdiction of CAS to award as they see fit, an athlete can end up with quite a significant amount of liability. And I'll just give an example from a case that I was involved in. The case of Kamila Valieva, who's a Russian skier who went through a long CAS process following a positive test before the previous Winter Olympics. She ultimately was ordered to pay tens of thousands of Swiss francs in costs in relation to an appeal that was brought against her, despite the fact that she'd been successful at her own appeal panel within Russia. So it illustrates how the process can be a real challenge. And just to pick up on three of the points that Mr. Justice Dahal made, I agree with him that the speed of process, given the perishable nature of disputes, is a real factor. CAS generally is quite quick, but decisions can be slow. And decision delayed is really, justice delayed is very much justice denied, and that is an ongoing challenge. The fascinating point that Mr. Justice Dahal made about the fact that CAS in effect rules on the legal interpretation by legally constituted bodies within a jurisdiction is something that remains a very thorny issue. CAS is an arbitral body, but is often ruling on the decisions made by legal bodies at a national level who have applied their own domestic laws. And so for an arbitral body to, in effect, be asked to interpret and apply the national law of another country, especially when that arbitral body is operating according to Swiss law, creates all sorts of, as I say, thorny and interesting issues that remain somewhat in the difficult box when it comes to us resolving those. And then finally, the point Mr. Justice Dahal made about the Eurocentrism of CAS, I do tend to agree with that in that CAS remains a very Eurocentric, Euro-focused institution. There are notable exceptions to that. The ad hoc division follows the games around wherever they're located, and CAS does operate in other jurisdictions where, such as Australia. There are extensions of CAS in other places, but generally that centralisation in Lausanne does act as an operational deterrent and a dampener to the perception that athletes have that they can go there and enforce their rights. And I appreciate that CAS, being many thousands of miles and several time zones away, is not something that's appealing when it comes to an athlete's decision to enforce his or her rights to challenge a decision. So in summary, I would say that CAS has a very central, a very important role in delivering harmonization and consistency across the anti-doping movement, but it's not without challenges. And I think it's for us collectively as practitioners, as stakeholders, to recognize those challenges and work together to produce solutions. The easy part of identifying challenges is identifying them. The more interesting and more difficult and more challenging part of recognizing difficulties is also preparing and proposing solutions. And today's event is a really important part of how that process can proceed. So with that, Professor Paul, I'll close my remarks there. I'm sorry, I might have gone over a little on time there, but I hope you'll forgive that. Thank you.
Thank you so much, Mr. Arthur. Actually, I'm already enjoying the expert colloquium, which is not just paying a lip service to the colloquium, but actually the experts are engaging with each other, asking questions and deliberating on the issues which are there. So thank you for sharing the contribution of the CAS, the challenges faced by the CAS, and also sharing your own personal experiences with the panel today. Thank you, Mr.
May I just put in a little footnote, Graham? That was an excellent response and very constructive for all these issues that we have been discussing. So thank you for your candid response. Thank you.
So that brings us to the third speaker. So before I invite her, so I would like to introduce the topic to the participants. The World Anti-Doping Code is the fundamental document harmonizing anti-doping policies, rules, and regulations across sports organizations and public authorities globally. Since its inception in 2004, the code has evolved through periodic updates in 2009, 2015, and 2021 to address emerging challenges in sports integrity. The interpretation of the code often centers on several key pillars like strict liability, harmonization versus flexibility, adjudication, when it talks about CAS. And then there are current debates within the anti-doping community highlighting several critical tensions like athlete rise versus surveillance, resource disparity. There are certain wealthier NADOs which conduct sophisticated programs. There are low resource nations which face challenges with laboratory accreditation and procedural delays. There are issues of geopolitical friction. And then there is this controversy which persists regarding the TUEs, whether TUEs create a backdoor for doping, particularly for conditions with subjective diagnosis. So I hope Professor Lovely Das Gupta is going to be addressing some of these issues in her topic, which is World Anti-Doping Code, Compliance, Interpretation, and Emerging Tensions. Over to you, Professor Das.
Thank you, ma'am. Hope I am audible. Yeah, right. Thank you all. And I'm in a very august gathering. Justice Dayal, Anish sir, we have had the privilege of his company at NUJS, though again virtually at that point of time, but Vidushpat is there, and it's been a great pleasure to have interacted with all of them. So without much ado, I'll talk about the topic. World Anti-Doping Code is whether we like it, we hate it, but we cannot ignore it. And unfortunately, it is a fact that India is, whether it tops in medal list or not, it is definitely topping in terms of the doping cases that we are getting caught for. And as per the World Anti-Doping Agency's report, India is, the top of the tops. So I know the NADA is there and all the officials and other people are there. It's not reflecting upon any of them with all courtesy, but the fact remains that despite years and years, and Vidushpat has been closely involved with Mudgal sir, and there have been reports presented. We just have not, I don't know where we have failed. One has to really do this introspection, and since NLU Delhi is taking up this important task of sensitization, advocacy, research, publication on doping issues, this is a key aspect as to where does, as Dayal sir was saying, as Justice Dayal sir is saying, that it is a key issue as to where our athletes are falling behind. Is it the fault of athletes? Now, when you look at the World Anti-Doping Code, it is very clear. Ma'am, we have highlighted strict liability principle. We cannot ignore it. Whatever we may feel empathy, sympathy for anyone in this world, athletes are the fulcrum of this entire anti-doping regime. The athletes have the burden. We have seen it in the, in number of cases. For example, in the Sun Yang case, the Chinese swimmer case, which is very, in the recent past, though he has gone in appeal and then ultimately he was imposed with the sanction. But the fact remains that whoever may be responsible, the systems may have failed the athletes, but athletes bear the burden. Look at the case of Maria Sharapova, such a high-profile athlete. She was having this medication which was found to be in the prohibited list, and she was caught for anti-doping violation. But I think as our, as we just had a presentation on CAS, the grouse or the grudge comes that despite the diversity of the CAS panel, the fact remains that CAS also is, is bound to go with the evidence that you have produced. And unfortunately for today, an athlete cannot just have an athletic skill. The athlete needs to have a contingent of scientists, doctors, lawyers, and all kind of advisors. You cannot, and Indian athletes cannot just do with Sports Authority of India and whatever resources SAI is providing. You have to have a contingent dedicated to athletes. Look at the support staff. For example, Novak Djokovic, he is at this age of 38, the way he is playing. I mean, and he will never be caught for doping. But the fact remains that the kind of contingent he has, it's not about just going out there and playing, right? If a coach, now when we have the national, when we go to our coaching centers in Patiala and all, we have our coaches, and the government of India is doing its utmost to provide coaches and foreign coaches and best of the state of the art training facility and everything fine. But when you look at each of our athletes who are caught for doping, right, what is the reason behind their failure? Because the compliance, the first aspect of WADA code is compliance. And who is the fulcrum of this? Who is important? Who is the most important stakeholder in this compliance structure? It is the athlete. Because your doping definition, there's no definition of doping. You look at the list given there, Article 2 of WADA code, it just gives you what an athlete does and doesn't do, what the do's and don'ts by an athlete is anti-doping if they don't do what they're supposed not to do, and if they fail that compliance. So how do you place it? Coaches comes later, system comes later, government comes later. But what about an athlete? Where will the athletes go? We agree that we are now the other aspect, we have now the 2027 code coming soon into force from 1st January 2027. The versions are there, everything is available on the WADA website, one can go through it. When you look at it, they are emphasizing a lot on education program. WADA has come up with the international standards of imparting education. I think we have to not only educate the athlete, we have to equip them enough with that kind of expert support system. It is not enough to have coaches. It is not enough to have trainers. It is important that every athlete should have a team, a contingent of lawyers, of scientists, of coaches, of nutritionists. And it is not a generic approach. When they go out for training, our own athletes, when they go out for training in SAI, most of them are given a setup, but they are not given individual contingent. When they go out to play there in international, not everybody is PV Sindhu, not everybody is Bindra, not everybody is Neeraj Chopra. What about the other athletes who are participating? And as as was clearly shown, let's say we're talking about the national level athletes, and we are talking about the national sports, and they participate, right? So they are educated. They know that they are not supposed to take this and that and that. Now, but what if they take? If Maria Sharapova at that level, she can commit a mistake, why can't they? And as it has been very clearly mapped out, and it is evident that most of our athletes, they do come from the back. Even an urban person will not know. When we buy a medicine, we don't always know what is the chemical composition. And if you look at the prohibited list that WADA publishes every year, you see they provide you with chemical composition. Now, yes, one argument is that the NADO, for example, Australia has a fantastic what we call education and an anti-doping and support system. And let's say Indian NADA, sirs, the officials are there, all people are there. The question is, when you look at the list, do we tell them the kind of medicines in terms of the brand name that will have those chemical composition? That is the level of education you need to have, so that when they go for over the counter, they are clear that this is not to be taken. Secondly, when they go for national, and I'm talking about national sports that we conduct every year, if we are having athletes who are getting caught for doping, the reason is they say, yes, our coaches have fed us. There are many, the kind of, we can see the cases there are up there. If you just check the, appeal cases and the decisions that are coming through and through, you'll see the kind of arguments they give. We apply cream, their VLCC cream on my skin, and it has This is the level of argument, such a basic, mundane argument. How do you think they will fight it out there on scientific parameters to show that this is not possible? Richard Gasquet case is one of the most famous case, which is the level of sophistication of argument before CAS. He was supposed to have in his sample a prohibited substance was found. The way he established no fault, no negligence. Why? Because he said whatever was in his system went through kissing or that he had indulged in with his girlfriend. Can you imagine any level, that level of scientific support Indian athletes have when they go before CAS? That's the problem. It's not only about the fact that they're coming from rural background. It's also about the fact that they need to be given. So when you talk about WADA compliance, yes, India has to. We have seen what has happened in India, right? We have undergone bans, then WADA has restored our accreditation and everything. We have gone through the entire regime. And ma'am has highlighted therapeutic use exemption, whereabout clauses. These are standard. What will you do with it? We can debate on it, we can criticize on it, but that is there. The question is, we have to, it's like this. When you cannot beat the system, you have to join the system. WADA is a necessary, WADA, World Anti-Doping Code. WADA code is our necessary evil. We have to learn to live with it. Instead of giving excuses of a developing country, we have to now act like one of the developed countries out there. We have to, why can't we have, let's have a smaller contingent. Let's have, let's try to think over. How do we provide our athlete with that support that they can match the system? It's not enough to give them training as a sports person. It is also important that we do provide them with this contingency. This is my submission. I've written it. I keep on arguing it wherever I get a chance. That WADA code, and if you look at it, the 2027, as I said, is heavily oriented towards education. Fine, you have education. Fine, you convert it into vernacular languages. Fine, you conduct workshops. But in reality, at the ground level, what kind of assistance, support are they getting? That is my submission. And that is what I think India, unfortunately, hasn't been able to do. And that is the reason that even the latest data which WADA agency, World Anti-Doping Agency, has published in his website, you can all see India tops the list of the most doped athletes in the world. How is it possible? We need to have answers for that. Right. So this is where I will rest my submission.
Thank you so much, Professor Lovely. It is always a pleasure to listen to you. Thank you for bringing the importance of WADA code, also highlighting the need of the proactive steps that needs to be taken to support the athletes at the very local level. I'm sure people who are listening to all the inputs, there will be some change which will be done. There will be certain proactive actions which may be taken in future to address issues. That brings us to a very important topic, which our fourth speaker is going to address, which is athletic sanctions are evolving from purely punitive measures towards a holistic rehabilitation and reintegration model that prioritizes mental health, education, and safe return to play pathways. Modern approaches seek to prevent athlete ruin by treating sanctions as a continuum of recovery, much like an injury, rather than a definitive end to a career. Traditional anti-doping and behavioral sanction often lead to athlete isolation, stigmatization, and severe mental health risks, including anxiety and depression. Current reforms advocate for a more equitable balance, and the return to play pathways is a transitioning from time-based waiting period to criteria-based progression. I am happy to welcome Mr. Siddharth Nayak, who is going to be talking about rehabilitation, not ruin, rethinking sanctions, return to play pathways, and athlete reintegration.
Thank you, Dr. Rohi. I hope I'm audible to everyone. Since I have this fortune of having Justice Dayal and Vidushpat and Graham, I'm going to more of rant as an industry colleague, the dilemma that I face as a sports industry practitioner versus what a student of law would see. The law in book and the law in action, the difference is quite apparent, and you deal with it on a daily basis as you grow your practice or delve deeper into the subject. So, on one hand, while you assume, presume, and see that the whole process of policy making, as Justice Dayal pointed out, even leave adjudication process or the representation, even the policy framework is Eurocentric if you look into it. So the basic meta study that you need to do, your sample size and the what do you call the grassroots data that you need to collect, that also is Eurocentric. If you look into how the policies are framed at the International Sports Federation levels or IOC or WADA. And then what is alarming concerning is that there is a lack of victimological approach. So no matter how much policies you draft or how strictly you implement them right from a grassroots level, you have to realize that athletes are not the benefactors of these policies. They are the victims, or at the end, they are at the receiving end. And you have not categorized the different categories, strata, background, and the racial diversity from where the athletes emerge from the grassroots level to the international level. As Dr. Lovely also pointed out, let me elaborate a bit. So we all know Jannik Sinner case. On one hand, you have one of the topmost tennis players in the world who says that the prohibited substance was found in my body because my coach bought an antiseptic cream over the counter for my physiotherapist, and he was massaging me, and that trace somehow could have transferred into my body. And everybody accepted it, and it was widely debated that across the globe that what could be or what ought not to be, but very few would have the access to know the interesting details without commenting on the merits of the case. I have a client who won an Asian powerlifting medal, and there was similar trace, same substance was found, and we were submitting reports pertaining to which are barely 2 months back from credited laboratories that see her blood sample did not have that particular trace. Had she been consuming, then it would have been detected, and those parameters or the detectable substances are not going to affect her performance in the event. That was turned down. She comes from a poor background. Justice Dayal emphasized on it that access to justice for the athletes, so far the CAS modular framework or the WADA framework is concerned, is as good as negligible. She somehow managed enough money to do a sampling for a sample B report. So when WADA officials at the international site or the NADA officials collect the samples, they categorize into category A and B, which are stored in different laboratories, the accredited laboratories, and you have an option to evaluate it. So the cost of evaluating the sample B, the invoice which was sent to us by the International Powerlifting Federation was $1,000. This poor girl comes from Udupi, and a household consists of four athletes. All of them barely have anything, and the entire household is running at an expense of 35,000 INR a month. Suddenly started burst into tears in front of me, saying that my chances went, even if they provisionally suspend me. The minimum tenure that I'm getting is 2 years. Asian Games will go, the World Championships will go. I'm ruined, and I would not even qualify for a state job if I don't play, and they would not allow me to compete at any level, starting from the district level to the national level. And the decision which came from the panel of the International Powerlifting Federation further imposed a cost on her, which has to be borne by her alone. And she's like, I'm as good as I cannot pay anything. Now, this is what the disparity I'm talking about. There is no dearth of economics, there is no dearth of applying a brain to have a standard adjudication or a process manual in place that takes care and addresses all these issues. Recently, we worked with Army Sports of Institute extensively for a period of 4 months to uniformize the training athletes processes because a lot of them were getting the NADA sanctioning notices. So we figured out that something is wrong with them. And while you cannot always address the elephant in the room, So there is a beautiful word in our profession known as mokita. So mokita means the truth that everybody knows, but nobody admits inside the room. And in the circus of compliance issues, in which kind of forms the bread and butter practice for me and Vidushpat, we know what happens at the governance level and the EC level, how the so-called independent panels are formed, which unfortunately Justice Dayal can't comment upon considering his stature now. But I'm pretty sure as a practitioner, he would have traversed through the same dilemmas as well, and which is primarily 90% of the ranting and the chatting up gossiping in the corridors that we sports lawyers do amongst us. So when the entire machinery of having an independent mechanism is only good on books and is failing at the practical level, access to justice for the athletes is a far-fetched dream that you can think of. Now, tell me, all of us are industry experts, most of us are over here, the so-called, thankfully, Dr. Rui Paul considers us as industry experts. Is it so difficult for WADA to have an independent process manual for appointment and composition of the arbitration dispute pertaining to anti-doping rule violations at the international federations? How many federations are there? 46 international federations, 28 for the Summer Olympics, 7 for the Winter Olympics, 11 other recognized. You cannot keep a roster of medical practitioners, lawyers, and everyone who have been standardly trained through a proper mechanism by WADA and make the international federations that you please appoint from that particular roster. There would be uniformity in your own rulings, appeals, and sanctions. But you need the will to implement it as well. And all this independent arbitration panels and the disciplinary committees and everything are appointed at the majority of the strength what the executive council member at the international federation or the national federation would want. At times, there would be some symbolical representation. Oh, see, we have a South Asian member on the panel, we have an Indian on the panel, and those are tokenisms that goes forward. So what is being shown is not implemented at the practice level at CAS as well. I would assure you it in writing that we have excellent lawyers with non-parallel legal acumen who would obtain excellent results with the same set of facts and argument before any other international arbitration panel or forum, say CIARC or LCIA, but would not succeed in CAS. CAS is Eurocentric, there is no doubt about it in the precedents, in the rulings, and everything. But more so, I would say it's Euro soccer centric in terms of the industry practice that we see. And the access to CAS, please take it out of your mind that CAS as a forum has developed where people or athletes from the national sporting federations would have an easy access. You need deep pockets to access it. Even the nominal, so-called nominal fee is too much for the athletes of various other countries, which you cannot comprehend of. Coming back to Army Sports Institute, I was extremely inspired by the approach that they followed. They said that all we need to do is to hire two B pharma experts. They would tally the list of the substances that is being banned by the WADA and the list of all the approved medication by the CDSCO. It's a central entity that controls in India what drugs ought to be released in the market and not, and take out the chemical composition tally, which I think Dr. Lovely was emphasizing on, and we will circulate it amongst all our clinical doctors that so far, whenever our athletes walk into our in-house doctors and everything, they have to ensure that these medications are not given. Despite that, few of their athletes face the NADA sanctioning because under the therapeutic use exemption, because of the language barrier, also for whatsoever reason, again coming back to Mokita, these people in the report of the findings, they said that, oh, you did not disclose it when you were being discharged from the hospital. My cross question to the panel was, what deterred your official to take the same answers from the doctor who's operating? If he has interacted with him for 30 minutes, the prescription list and everything, you could have asked for it, and the doctor ought to have furnished the same to the visiting official. But as I said, there is a lack of uniformity, there is a lack of process manual, there is a lack of independent mechanism in which the people who are at the helm of taking decisions and deciding on the life of these athletes across various jurisdictions and various economic strata backgrounds ought to be appointed, constituted, and conduct their business. So that has always been there. The victimological perspective has not existed, the uniformity has not existed, and the Eurocentric ideas have prevailed, which gradually would change. I'm not saying that. At the end of the day, when the volume of practices and prominence is increasing in terms of the industry business, because everything eventually flows from the capital factor. So the more influence you have at the industry in terms of your visibility and capital, the more influence a particular country would have at the international level. We cannot crib about the same position with ICC in today's time. When there was a time when we were literally begging for our seat and flight tickets for the ICC panels, in today's time, we know that we are a dominant representative over there. So things would take time. Things would take time to change, but these three aspects can very well easily be implemented. So my point of cribbing about it or ranting about it is that something that is so simple to implement, not at a mammoth scale, something that is so structurally fundamental, has been ignored over the period of years, not because of the lack of will, but there is a deliberate approach towards it. So the current testing mechanisms, including the random testing mechanisms, have multiple loopholes. See, if a state-sponsored doping activity is to take place, or some athlete really wants to perform at the global levels, there is always loophole. So your weight category cuts are anabolic steroids, which have been used over the period of years, has not been detected, but you jump back into your weight category. So few things are very obvious, but yet the rules exist for the sake of existing. So the calendar timing of the scheduling this test and to have a structured uniform database right from the state level, national level to the international federation needs to be implemented, and that is something very fundamental. If WADA and IOC mandates the International Federation as a precondition for their affiliation status that all your registered athletes need to have a weekly WADA lab tested report submitted, and only those athletes would qualify further for the international events, including continental and international championships. It provides a sum and substance and a legitimacy to avoid the loopholes. Speaking about the grassroots level, every National Center of Excellence and Sai Academy would have at least 5 vendors who have supplement stores where athletes, if they're caught, they can always procure backdated receipts to justify their story that so and so batch number of so and so product dated so and so year was consumed by me. That might have that report, and the spike those products and the uniformity labeling and everything is a joke so far. All this, so it's not only one entity that needs to be working in tandem. You need multiple entities. You need CDSO, you need FSSI. So you need a structured approach to all this process where these loopholes are addressed right at the grassroots level. So instead of encouraging finding loopholes in the testing mechanism, we need to approach the entire process of evaluating and imposing sanctions in a fashion that deters and penalizes those who are the actual culprits behind the athlete training model or the customary practice of doping in order to perform. And often you would be surprised that there is a deep held nexus between the coaches, the state federations, and the national federations as well, who know everything yet would refrain or show favoritism. At the end of the day, a national sports federation or the international sports federation performs or functions in its behavior as the executive council's mandate dictates. We agree to that portion of autonomy. There needs to be some degree of autonomy and a large degree of autonomy, which we recognize in international law, which has been adopted by IOC and the IFs. But so far, these alarming concerns are concerned where lives are at stake and the entire agenda and objective is being affected. We need a standardization of the process with a victimological approach. So I'll end my time over here without taking any further time of the panel. And thank you so much.
Thank you, Siddharth. for highlighting the issues and also giving suggestions how proactive steps can be taken to address those issues. Also bringing in the victimological aspect, which is much needed and the need of the time. Thank you for your inputs. Now we move on to the last speaker. So regulating clean sports in India is primarily governed by the National Anti-Doping Act, which provides a statutory framework for the National Anti-Doping Agency, NADA. Despite legal foundation, India consistently rank among the top countries globally for anti-doping rule violations. There are a number of practical challenges which are being faced here, like inadvertent doping, which most of the speakers were talking about, contaminated supplements, contaminated samples, over-the-counter medications, etc. Infrastructural gaps, because India relies heavily on a single accredited lab, which limit testing capacity and can lead to procedural delays. There is a debate, ongoing debates about strict liability and athletes' right. There are procedural delays. Cases have historically faced significant delays, sometimes exceeding 1,000 days from testing to final decision, effectively derailing the athlete's career during the interim suspension. Then there are cultural pressures, environments like win at all cost mentality among coaches and support staff, sometimes which often forces the athlete into doping. So these are some of the practical challenges. So I'm sure that Mr. Vidushpat is going to be including these in his presentation on regulating clean sports in India, law, policy, and practical challenges. Over to you, Mr. Vidushpat.
Good evening, ma'am. And first of all, let me congratulate you for setting up and hosting the UN's UNESCO chair for clean sports in India. That's a really brilliant and excellent initiative. And I thank the National Law University, Delhi, for hosting this, as well as having us here to discuss this at the first international session. It's really a tall order you've given me to follow Justice Dayal, Graham Arthur, Dr. Lovely Das Gupta, and my colleague Siddharth, who've taken up most of the points I would have wanted to address. But let me, I think the mandate of what the topic is clean sports in India or regulating clean sports in India. I will try to address doping, but I will try to go beyond it because clean sports in India, in my understanding, is not only about doping, right? So there are four facets I would assume for pertaining to clean sports. I think Justice Dayal touched upon it a couple of times. The first is obviously cheating in sports competition through a prohibited method or a prohibited substance. That is within the realm of anti-doping. And I'll also touch upon the issues or the practical issues that arise for athletes as well as even for doctors there. The second is cheating or manipulating sporting events itself. Now that is largely regulated by the anti-corruption codes of the international federation and the domestic federations. And the government of India also made an effort to come out with a sports fraud bill to that effect. Unfortunately, that bill has never got enacted, but the anti-corruption code of most international federations deal with it. And that is the reason, and that was the basis of the IPL probe that the Supreme Court looked in 2014, with Justice Mudgal committee giving the fact-finding report in 2016, and then Justice Lodha coming out with wider punishments for certain errant people, as well as suggesting governance norms, which became the mandate for BCCI and the state associations, and have largely been followed by other sporting bodies as well. And that came in addition to the erstwhile Sports Code of 2011 and the various decisions that the Delhi High Court has actually stipulated and laid down. It has been the leading High Court, with Justice Dayal obviously being a part of it now. So Delhi High Court has really been at the forefront of proactively laying down good governance norm for sports federation in India, and that has really improved the situation from when I started as a sports lawyer in 2007-8 to now, when there are norms in place, there are ways to challenge it, and the courts are stepping in on a regular level. Good, bad, but that's really what's happening. The third is cheating by violating the rules. Now, there are, and just to give an example, in football, if you get 2 yellow cards, you can't play the third match. So then people try to violate that. You can only have 3 foreign players. If you put the fourth foreign players, people try to manipulate that. So those are kind of other challenges which are also a challenge to clean sports in India. I think
So I
so
will
again, that
request
is something.
the others to please switch off their
So
mics.
again, for that also there are mechanisms in place. Just to take an example, for cricket has unauthorized leagues, and then they have anti-corruption code and player registrations and XYZ. In football, then you have the player status committee and the player status regulations, your the intermediary regulations and multiple other things. And then you have various bodies set up by these federations, which have legal experts as well as administrative experts who decide on those disputes. I think a big challenge that I think Siddharth was highlighting is the composition of sometimes these panels, or whether they are people who are truly independent or not, and whether sometimes they are competent or they are able to decide on those issues, because sometimes the issues are very intricate legally and sports law wise, and therefore somebody who does not have that training may not be able to understand the intricacies and decide on that. So I think that's again a big challenge that we have. The fourth aspect that I thought about cleaning sports in India is bias and corruption. I think this is something that Justice Dayal also touched upon. And this could be in touch with bribes, it could be biased in selections, election issues, and bribing and manipulating electoral college there. And that we've been working with various Supreme Court committees, say for in Hyderabad cricket, for Bihar cricket, and for other national federations. And what we find is if a constituent member is not convenient to somebody who's in power at the top, they will debar that person, they will debar that particular association, they will appoint another, they will get a parallel election conducted for that particular association. There will be ad hoc bodies that will be created for this association, and that is how the electoral college is manipulated. Now, that challenge vis-a-vis, now once that is done and the election is underway, courts are reluctant to intervene because the general law is that when elections are underway, the court should not intervene. But the Delhi High Court has intervened a number of times when there's gross violations. But that is where the checks and balances also come in, because I think corruption really starts from who are the people who are getting appointed. And if they are getting appointed by corrupt manner, uh, the entire system really faces a challenge. I think those are aspects that I wanted to highlight upfront as the four aspects pertaining to clean sports really that we are looking at. For anti-doping, I think everybody's touched upon it, that the WADA and the World Anti-Doping Agency and the National Anti-Doping Agency all have a principle of strict liability. And the strict liability is that you are guilty unless proven innocence. Whereas in criminal law, you are innocent unless proven guilty. And then comes the aspect of all evidence and all experts being stacked up against you. So a poor athlete, when he comes to us as lawyers, we are literally trying to counsel them, trying to advise them, as well as trying to get scientific evidence, gather scientific evidence and other evidence without actually have in a time bound manner, without having the resources. So that's the kind of an uphill challenge that we face when we are representing athletes, be it the National Anti-Doping Agency as well as the CAS. Uh, uh, I have a deviation. I agree that CAS was very, very Eurocentric and very uh, not understanding what was happening in the developing world, but I have seen that change as well now. So I'll first 10 years of my practice, I thought that that was the case, but now we recently arguing a number of matters as CAS, and what I'm seeing is that the perception is changing. And a couple of things I wanted to maybe give kind of something as a takeaway from what I have picked up at CAS is one, the legal aid is readily available for athletes now at CAS if you apply in time, and they extend the timelines for it as well. B, the anti-doping hearings are now become cost-free. So if it is an appeal from an anti-doping panel from the National Anti-Doping Agency even to CAS, the hearing itself is you don't have to pay that 1,000 Swiss francs for the administrative cost. That has become cost-free. What is the concern is the WADA is on the other side. A lot of times they ask for legal costs if they succeed. And what I think Siddharth and Graham and Justice Dayal were highlighting is that WADA has a level of scientific experts and studies and the lawyers who are regularly doing that, and you are against an athlete who has none of the resources. And I think that's the uphill battle that we fight. And that is where the advanced costs sometimes come in. But advanced costs generally come in for commercial disputes and regulatory disputes pertaining to like these rule violations and where there are clubs and those involved. So sometimes they are able to bear that. and you can mitigate those costs by going for sole arbitrators rather than going for multiple arbitrators, and even pushing for short timelines, and asking for even dispute resolution through written submissions rather than going for an oral hearing. So there are ways to mitigate it, and I thought let me address that because that is practically things that we've learned over the period of time, and those are some things that people can implement. Um, Again, Justice Dayal and Mr. Graham Arthur again highlighted, and that's really something that we are also really concerned with, that CAS is really an arbitration panel, means that parties have consented to appeal in an arbitral process, which is really what they've, and the way the kind of rules and regulations were built in and how it has been interpreted over time is that because an athlete has accepted the rules and regulation in a tacit manner, he's agreed to final arbitration by CAS. But now with Sports Act, that's the law of the country. So there is no acceptance or tacit acceptance or any other way of an athlete or any other person to a resolution of dispute with the sports tribunal which is going to come in. Now, when that comes in, how is that going to be built into an arbitration appeal? Is something that I think I'm even also struggling with, and I think probably we will see some kind of jurisprudence coming out, hopefully from Justice Dayal from Delhi High Court very soon. Uh, what also happened is WADA has also evolved. What they have now done is they've appointed an ombudsman. Now we've had a chance to deal with the ombudsman who's independent of WADA, so very athlete centric, listening to the athlete, listening to the athlete's problem, and then actually internally highlighting the athlete's issue within WADA. Even when a NADA is also with doing a concern or they're not working a certain way, an athlete can address that issue to the WADA ombudsman, and they will actually through WADA or directly address the athlete's rights issue with the relevant authorities. So that's again something really good that the WADA has started about a year and a half back. We've used it, and I think it's been excellent. We've really found it to be really good. On the decision-making process, board NADA as well as CAS, I've had decisions when operational decision may have come in 30 days or 60 days, but the final decision has not come for 2 years plus. So I don't think there's improvement there as well. While costs are asked for very fast, but a decision does not still come for a year and a half, 2 years there as well. So again, something that needs to be done there, because if suppose you want to appeal to a Swiss tribunal, if the decision is not as per the policy or something, you can't wait for 2 years and then appeal 2.5 years, and you can't appeal till the time a written decision comes. So again, those are really issues that are practically concerning when we talk about CAS, when we talk about anti-doping. The Delhi High Court and has really expressed opinions recently, like the financial burden issue was addressed by Delhi High Court in Dharamraj Yadav versus NADA, where they said that there's too much of an economic burden on the athletes and therefore they should be facilitated. And now NADA is putting in legal aid as well, and that's really good. I think people were addressing this whole aspect of only pharmacological or salts being told in the prohibited list and not being available for information to the athlete was a really big concern. This is something that we also tried to set up, and I think Justice Dayal was a part of it when we were sports lawyers trying to address that. NADA has actually started a Know Your Medicine portal where they're actually I think picking up all the medicines that are coming out recently and then trying to update it with what salts they add and whether they are banned or not. So athletes can use that. So there is some kind of mechanism that they are doing. So it's not that all is bad. Things are improving, but it's what I think the only thing is they're not improving at the pace which we need it to improve, because India is at the top at the anti-doping violation list. What I think is also a concern, and this is something I've regularly seen, is contaminated supplements, uh, medicines, seniors of athletes actually telling the junior athlete who are ignorant or to a large extent to take certain things, coaches, because they are getting financial incentive from government, state governments as well as national government if their athletes perform well, so they get incentives, so therefore they actually spur doping as well. And one aspect which I have seen practically, and that's the most difficult thing to prove, is sabotage, because there will never be a video evidence available and no other athlete will accept that I've sabotaged another athlete's thing, and this is regularly happening. I'm telling you, this is regularly happening in sports because there is competition, and Indian athletes are lax as trusting athletes as they trust. So if they will leave their bottles at the wayside at the stadium, they will leave their food, they will leave their supplements open in the room, and that is where a lot of kind of this sabotaging is happening. Uh, I don't know how this needs to be addressed. Maybe a fact finding, maybe a criminal inquiry, because some person or some people need to be taken to task. Because this will not happen within the anti-doping system. This will have to happen outside the anti-doping system. So some people will need to be taken to task, and I think examples will need to be made out before I think a cleanup happens. Because I would say there is a 20 to 30% of sabotage is the real issue as well around that. What is also happening is a lot of time the DCOs are on a contract basis rather than permanent or really experienced people. So they are really concerned short term, doing testing quick and leaving, and therefore they are not sometimes compliant with the stipulations that are placed upon them by WADA. Well, athletes, while is strictly liable, the DCOs are also strictly liable for following the guidelines, which they are not even aware of a lot of times. And therefore, sometimes they leave the samples open, they leave it open in the doping control center, they run away, they are busy with something else because they have to do certain number of testing, so they don't plan their testing properly, so they are wavered. So I think those are really big challenges also that are happening, and eventually the athlete is always to be blamed because that's the easiest way to shift the blame on the athlete and then let him fight it rather than taking the blame on the authorities. But that's again, that's not the NADA, that's actually some DCOs who are contracted people who are getting employed. So I would not put that on NADA. One more aspect on anti-doping front, I'll just maybe sum up in 2 3 minutes. I think I'm going over time. Is out of competition testing. Now I've had represented multiple athletes. Now they are supposed to give details 60 minutes, at least elite athletes who are in the registered pool of 60 minutes wherever they are each day. And believe me, it's to think of that also is it gives me anxiety. Now athletes are required to comply with it, and if they fail to do it, suppose suddenly they get called, मंत्री जी ने आपको इधर बुलाया है for a welcome ceremony, or they suddenly have to somebody falls ill in the family, they have to go to the hospital or somewhere, and they forget to log in their whereabouts, it's actually treated as a missed test, and twice or thrice it happens, they get banned. So I think that is what I think was being highlighted. You need an entire contingent to handle an athlete, because how can if an athlete was doing it to be regularly be able to update and be so vigilant? Either he has to play the sport, or he has to handle his nutrition, or he has to handle this anti-doping. What all can he handle? I think we are expecting athletes to be superhumans if we are expecting one single athlete to be able to do that. So I think that's something of a concern that again needs to be checked and developed. Um, on the corruption front, again, IPL, I think the report is there. I don't need to spell out. I think everybody's read multiple aspects of it. There is a sealed envelope which is still sealed in Supreme Court. But there's a Manika Batra case as well, which is there, where the coach actually was motivating the athlete to throw away the match. Now, nobody would have known that the coach was motivating, and it was one person's against the other, word against the other. The athlete was just smart enough to record it at that point of time. So she was just extremely vigilant, and that is why that case came out, to the extent that the federation's election had to happen. So imagine one corruption scandal of one coach led to an entire federation's governance getting changed. So that is a solid impact if an athlete is vigilant and is able to bring that forward. Justice Rekha Palli, Delhi High Court, really then took after the TTFI, and I think she was quite strong on kind of corruption that happened there. So those are kind of things that actually change. One small incident changes the entire diaspora of governance in a particular sport, and those are things that really get highlighted on a larger level. I think with that, I will stop. Again, the small thing, the anti-corruption, we have good BCCI anti-corruption unit. I've seen them function excellent, I would say. Again, nobody can curb everything. I think when we are doing the IPL probe, I think one thing with Mr. Dravid said really that clicked and really stayed in my mind is there is no price for greed, and nobody can cure greed. So while there's always going to be motivations to be corrupt, that is because of some greed or the other. Whatever system you can put in place, you will never be able to stop it. So it has to be both ways. You can put enforcement systems in place and checks and balances, but you have to motivate the athletes not to go that way as well. And that is really something which will come through education, through counseling, uh, through maybe guiding them and putting them more in a more structured format of training. With that, I will stop. Thank you so much.
Thank you, Mr. Singhania, for that very balanced presentation, where you highlighted the positive steps taken by various organizations, as well as highlighted the areas, gaps, and challenges that still needs to be worked and looked upon. Thank you so much for all the expertise that you have brought to this panel today. Now, I would like to hand it over to Ms. Udiksha for carrying it forward.
Thank you. Thank you, everyone. Thank you to all our speakers for what has been a very honest and necessary conversation. And if I were to draw one thread that connects everything that we heard today, it is that clean sports is not just about rules. It's about the system. It's about the realities. So if I were to conclude and talk about the takeaways of the expert panel, and I apologize in advance if I mismatch and if I simplify what our experts have said.
Udiksha, sorry, can we have the questions first before we conclude the session?
Okay,
If
sure, ma'am.
Yeah.
Sure, ma'am. We have a couple of questions from our diploma students, and Mr. Gaurav has put them in one place. Mr. Gaurav, if you could just put them up to the panel.
So hello everyone. So my question is, like, the anti-doping issues are often come late in the athlete career. So can we incorporate these values through school education or like any other system so that we can place like it into the process? Currently, we don't have any curriculum in schools where these values are taught. So could you please like highlight how can this be incorporated into the process?
Maybe I can take the question.
Yes, sure.
You can go ahead.
So when the athlete is coming into the competitive sphere, and be it a school game at a district, state, or national level, right? Because one is a recreational game which you are really playing at, say, a school level or house level. But as soon as you're coming at the competitive level at the district, state, or national, I think that is where the education could kick in. And what is happening just now is this education is currently being handled by the National Anti-Doping Agency and to some extent the Sports Authority of India at their centers of excellence, where this education is largely now there is a push, and again I've seen this, so there is a push of NADA actually coming with and working with the national federations and going down to the state and the university games and everything. So that is happening, and I think that needs to happen a bit more. The only challenge which I sympathize with NADA is they don't have enough staff. There are so many venues across the country. How much can 3 or 4 people educate so many people? So I think they need to educate the educators like the coaches and the other people at the schools and at the federation, and then they will also have to educate down. So I think there will have to be a chain that needs to be formed. And as I said, we are talking about athlete excellence. There has to be coach excellence as well, and coach education as well. And I think that this could form a part of the coach education module. And I think if that happens, then it will percolate down, way down into the grassroots. Because I understand the challenges as well of Sports Authority of India and NADA, but this needs to be done really.
We have Akansha who's raising hand. Akansha, can you unmute yourself and raise the question? Do we have another question, Gaurav?
Yes, ma'am, I have another question, ma'am.
Please go ahead.
Yes, ma'am. So, ma'am, my question is like with the growing sport disputes and the complexity involved in the sport disputes, can we like improve the cases like how the cases handled in India? Can we improve that approach, or can we have like one arbitration model which is suited to India?
Would any of the expert like to take this question?
See,
So
this
I
is
think the
a
question.
this is a complex issue. We have discussed it as just Professor Dasgupta mentioned. We have to go with the system because we have aligned with the global standards. So that's a starting point. We can't just pluck ourselves out of that because the sports is organized internationally as a uniform system. So we must accept it. We must work with it, and the suggestions which have come from all the members of the panel, that how the Indian system ought to have better facilities, better personnel, better organization. It's an infrastructural issue at the end of the day. So that has to be worked on. It requires the support of everybody in the system. And it's about time that Mr. Singhania mentioned that there has been a change in the approach of CAS. Some concerns are still there, which are slightly more in the difficult box, as Graham said. So all these things have to be ironed out. All to have to be ironed out. But the good thing is that all of us on the panel seem to be largely agreed on certain issues which need to be addressed. So I think that's a great start. And we have the NLU chair, Dr. Paul, who will now be tasked to take up all these issues. Somebody must have been taking notes. Very excellent points have come up. There's resonance on those points. And I think we will lose an opportunity if you don't use them to take things ahead. In offline conversations and offline discussions, we must do that.
Yes, sir. We will do that. Now we have Hanif, who's raised hand. Quickly, if you can ask your question.
Good evening, everybody. I'm Hanif Chundhanawala. I'm working currently in Delhi High Court under Senior Advocate Rahul Mehra. And this is a great opportunity. This is a good moment for me to ask a question or to just raise my viewpoints. A couple of things which come into my mind are that when we talk about clean sports, it's not just limited to NADA or doping, and rightly pointed out by Justice Anish Dayal that it's beyond that. So currently, and few months ago, I was a part of the case, and as Indians, we also know about it. There was a wrestling case which we talk about. When we talk about clean sports, we also need to give a clean environment, a safe environment to the athletes and players to function like that. Now we are aware about the wrestling case. When we go and we talk about these cases, the only point which comes to my mind is the federation and the people who are ought to be your backing system. If they backstab you, then where do you go? And the second point or second aspect, which when we talk about clean sport, is the mental harassment and the mental agony these athletes go through because of the trolling, because of the environment sometimes they are put into. So how do we as a society and we the federations as the backbones of the athletes help them and make them grow?
Thank you for your question.
Let me address that. So, Hanif, I was the counsel on record and I was in your chambers and you have worked in this matter. And I understand the query. And we have briefed your senior as well over extensive periods of months, but there is always a remedy available. At the end of the day, we exhausted the writ jurisdiction of the High Court. They interfered, they provided us the interim relief. And in most of the National Sports Federation disputes and these kind of disputes, where there is an upcoming athlete who belong to a particular lobby within the faction, and there is a rival faction, most of these cases don't see the light of the day of a detailed judgment. If you look into it, like Vidushpat can attest to it, there are so many cases which ultimately both the rivaling factions they shake hands together and the case goes off the grid. And as a practitioner, you are only concerned that I have put forth my face value before the bench and I've argued tooth and nail, but minus the client's mandate to represent them over the specific cause to go on further in the case, there is only so much you can do. So the litigants have often their ulterior motives, which they try to realize by replicating such issues before the bench or engaging lawyers or approaching the court. And on the alternative, as Vidushwat cited, it's not limited to doping only. So you in ICC you have something known as Anti-Corruption Unit (ACU), which is headed by one of the excellent guys that I've ever worked with, Alex Marshall, and you have alternative remedies available where you feel that you are being targeted or violated or being hampered in your growth within your national sports federations, then you can address it to the international federations. You can subsequently take it to CAS in that particular order, or you can always exhaust the territorial jurisdiction remedy that is available to you. That has always been the case. In Japan, you will find so many cases. In China, supposedly, you will find so many cases where these things, where one of the most prominent athletes went off grid because of commenting something funny about the government and regime, and she was in absence from everywhere. I think during one of the last sessions with NLU Delhi, I had covered that particular issue. And when the international federation stepped in and said that no, there is something fishy about it, so they were forced to ensure the safety of that particular athlete, and she was again seen in the cameras and everything. There was a lot of gung ho about it. So there are always options and mechanisms available. You have to be aware of it to exhaust it, which most of the prominent athletes are. And as their cases come before the forum and they get highlighted, the junior athletes and the upcoming athletes, they become largely aware of what remedies they have in such scenarios. And that scenario is never going to change no matter what you do, because you cannot please everyone within a autonomous structural governance mechanism. Not every EC member is going to be your friend or look into you as somebody who needs to be not be opposed or not. I mean, as Vidushwat cited, sabotage is an issue. So your fellow athlete will spike your drink, would sabotage your own career, and there have been cases in Delhi High Court about it as well. And you know the truth, and there is nothing you can do about it. So you have to be vigilant and be aware of your rights. That's the only remedy which is possible.
Thank you, Siddharth. We can have just one more question, which is I will request Ms. Ashwani Patil to ask the question briefly. After that, we'll move on to the closing comment.
Hi, ma'am. Thank you so much. Am I audible? Thank you so much. Thank you all the dignitaries for this very nice colloquium. I will keep it very short as we spoke about a lot of whereabout updates. I am a sports physiotherapist and someone practicing very closely on ground with the athletes. It is much rather seen as a barrier or a stressor rather than something that would support them with a channelized way of testing. So this is not just regarding the RTP testing pools, but also about the STP testing pools, where I believe the athletes who are in STP are also viable to whereabout failures, if not sample collections, and would just like to understand how we can further have a more supportive system on ground, say within the national federation or within the national teams, where STP whereabout update or an RTP whereabout update would involve just more than the athlete. Because again, like an ADRV, where the athlete is solely liable, even the whereabout updates is where somewhere the athlete who are again vernac and are uneducated and are not very tech savvy are solely liable for their whereabout updates. And this is somewhere maybe the national bodies or together as an ecosystem, if we can step in and provide that support so that the athlete does not see it as a stressor or a barrier, and have that confidence to share their updates, to be more prompt about it rather than see it as another stressor.
Ashwini, you can hear me, right?
Yes.
Yeah, so I think what you are pointing out and what is clearly, the problem, the obstacle, the lies in your question itself. You're saying that uneducated, vernac. So as I was telling in my, submission that this is the system. We cannot do anything with the system except to comply with it. Now, the concern is, how do you ensure that it is not a stressor, as you are pointing out, since you're working with the athlete on ground? And what do you think is the way out? The only way out is to kind of make them get used to it, train them. They have to be mentally prepared. And I know it's very easier said, but this is the reality. If you want to be an athlete, the problem is in India, most of the time, most of the athletes are being driven into sports. Largely, they are concerned with getting the job under sports quota. So for them, that is their, primary concern. So when they also have to do all the other compliances, and considering our constraints, and as Vidushpat sir himself pointed out, the logistical constraints that the governing organization itself is facing, you must be dealing with it, because you're working with the athletes. You must be seeing how lack you come across, right? But till we find a better way out, we have to start train ourselves and get used to it, that we have to do it. It is very difficult, next to impossible. Vidushpat sir was pointing out, suddenly I have to go and admit someone in my hospital, and how do I update? What do I do? There are no answers. If there would have been an answer, you wouldn't be attending this conference. Right?
So I apologize to I understand the curiosity the participant might be having. I will request the others to please write down your queries, questions in the chat box, and we will obviously get back to you, because in the interest of time, I would like now request Udiksha to do the concluding remarks. Udiksha, are you there?
Sorry, ma'am, I just didn't realize I'm on mute. Okay, so thank you to all the speakers, and the conversation was great and very honest and very candid. And if I were to give concluding remarks and say that, what is the takeaway of the session, I would just very briefly speak about what our experts highlighted on. Justice Anish Dayal reminded us that sports disputes are uniquely perishable, and time is very important, and a delay can cost an athlete season, a medal, or even a career. And his reflections on alignment between the CAS and the emerging National Sports Tribunal, or the kind of structure that we are coming up with, and alongside the questions of diversity and language. So they are reminders that justice in sport should be very timely. Then we had Mr. Graham Arthur, and he made a very important point, at least of what I understood, that before we question the accessibility of CAS, we must also look inward. And CAS is only as accessible as domestic systems that prepare athletes and lawyers to maybe reach it. And accessibility is not maybe just an international issue. It is shaped by domestic awareness, training, the kind of legal culture and the institutions that we have domestically. Dr. Lovely ma'am then took us to the regulatory realities. And like she mentioned that the World Anti-Doping Code might feel like a necessary evil at times, but it is the framework with which, globally all sports functions. And instead of resisting the high standards set by the code, perhaps we must strengthen our compliance, our education, and the contingency planning at the grassroots, especially when India continues to, lead in the anti-doping rule violations. Mr. Siddharth Nayak brought the discussion back to the athletes and also to the lawyers, and his point about the cost of B sample analysis was particularly very striking, the cost associated with it. And it also, confronts us with a difficult truth that sometimes, justice can be just an ideal when even the testing stage can be financially burdensome. So disparities does not necessarily happen at the adjudication stage. It might just happen at the testing stage as well. And he also shared from his experience that Indian lawyers struggle to succeed before CAS. And that is very uncomfortable, but I think a very, very important takeaway of the session. That accessibility is not just about athletes, but it's also about the legal representatives that go from one country. And finally, Mr. Vidushpat, I think, expanded the lens altogether, and he reminded us that clean sports cannot be just reduced to anti-doping. Clean sports also mean addressing, dimensions like cheating, manipulation, corruption, bias, nepotism, as also pointed out by Justice Dayal. And if we approach clean sports only as a doping issue, then I think we do miss the larger picture. And so perhaps putting it all together, the real takeaway is that we must be strengthening systems at every level, be it testing, be it the governance, be it the legal representation, or the domestic adjudication, as we're coming up with new institution, National Sports Tribunal, and the alignment of the tribunal structure with the ultimate appellate body, which is the CAS, is doubtful. And the athlete education, the integrity, and without all of this, I think access to justice remains just an idea, just a theory. And I think that's it. Thank you once again to all our experts for bringing such a clarity to the conversation. And I am very hopeful that we'd come out with a wonderful analysis as a result of this expert colloquium. Thank you.
Thank you, everyone,
Thank you
for joining us. Thank you.
Recording stopped.